Robby, what's on your radar today?
Well, Brianna, the federal government's vast and disconcerting campaign to curb politically disfavored speech on social media has finally encountered a setback. On Tuesday, District Court Judge Terry Doughty ruled against the Biden administration in a pivotal free speech case brought by Republican attorneys general on behalf of individuals punished by social media companies at the behest of the federal officials. Now, as my colleague at Reason Magazine, Eric Boehm, noted, quote, the underlying case alleges that coordination between government officials and social media companies, including Meta, the owners of Facebook and Instagram, and Twitter, routinely silenced opinions that challenged the mainstream narrative about the COVID-19 pandemic and other hot-button issues. That case is well supported by an ocean of evidence, including the various disclosures within the Twitter files, a series of independent journalist reports, and also the Facebook files, my own investigation into federal pressure on social media companies. Now, the hundreds of messages sent by employees of the FBI, the Centers for Disease Control and Prevention, the Department of Homeland Security, other agencies, and the White House to moderators at Twitter, Meta, and Google make clear that the federal government pushed the platforms to suppress dissenting viewpoints on a whole host of topics. Doughty's ruling is a preliminary injunction that bars federal agencies from engaging in many, though not all, of these behaviors. So the outcome has alarmed mainstream outlets like the Washington Post and the New York Times, whose reports included quotations from internet security experts fretting about the federal government's diminished ability to police speech online. Guests on CNN and MSNBC took an even more apocalyptic tone. CNN legal analyst Eli Honig assailed the, quote, aggressive, far-reaching ruling, while NBC News reporter Ryan Riley described a world free of federal pressure on social media platforms as one that, quote, we wouldn't want to live in. Riley also fundamentally underappreciated the scope of the pressure campaign, telling MSNBC viewers that, quote, it's not as though the FBI has been going in and saying, hey, take down that post. No, seriously, let's watch what he said.
Through kind of the parameters of this injunction.
Yeah, I mean, so it basically has some limits on what exactly the FBI, I think, most essentially is able to do. And I think that, you have to take a step back and acknowledge what the reality is about how the FBI has been interacting with this. And just look at January 6th itself, for example, right? It's not as though the FBI has been going in and saying, hey, take down this post, hey, take down this post. That's what they're alleging, but there's just not a lot of evidence to support that. And basically, we've had a situation where some politicians are making any contact between social media companies and the FBI or law enforcement seem problematic in some way.
Au contraire, despite what Riley just claimed, the FBI has done precisely that. For instance, the FBI frequently flagged joke tweets about the 2020 election, the election date, asking moderators at Twitter to take them down. The White House itself did the very same thing. As Doughty points out in his ruling, White House Digital Strategy Director Rob Flaherty personally appealed to Twitter to remove an account that parodied Biden's granddaughter. Quote, this is from Flaherty, please remove this account immediately. 45 minutes later, Twitter did just that. So if the judge's decision prevents federal employees from engaging in such heavy-handed muzzling, that would be a welcome relief. Unfortunately, there's reason to doubt that the decision will meaningfully constrain the feds. That's because the judge also drew up a list of actions that are, quote, not prohibited by this preliminary injunction. And this list could reasonably be read to permit the very sort of behavior, jawboning, that has produced the censorship. The judge's terms, for instance, allow the federal government to notify social media companies about threats to national security, criminal efforts to suppress voting, foreign attempts to influence elections, and communications that intend, quote, to detect, prevent, or mitigate malicious cyber activity. It's worth recalling that prior to COVID-19, many of the communications between the feds and the platforms, well, they concerned precisely those subjects, purported foreign influence, malicious activity, etc. When national intelligence officials cautioned social media companies about the New York Post Hunter Biden laptop story, for instance, they cited the threat of foreign election interference, efforts to purge social media of so-called Russian bots, which was in actuality a crackdown on legitimate speech expressed by real Americans, well, those were conducted under the auspices of malicious activity prevention. Will Duffield, a policy analyst at the Cato Institute who I talked to yesterday, he's similarly concerned that Doughty's ruling might not make enough of a difference. He tells me that the top half of the injunction reads like, quote, a complete and total shutdown of government communication with social media platforms until courts figure out what's going on. But the bottom half includes exceptions wide enough to include many of the most controversial government communications with platforms. Duffield said he would like to see federal legislation that mandates disclosure, forcing government actors to be transparent about their communications with social media companies so that they can be held accountable, even sued, if their conduct crosses the line into censorship. He says, quote, it's good to see courts taking job owning seriously, but this preliminary injunction illustrates how difficult it is to draw clear lines that prohibit government bullying without blocking merely informative speech. In the meantime, the Biden administration has declared that it will appeal this ruling. Federal officials will not willingly surrender their censorship tools, and the fight to constrain the state's ability to silence the rest of us, well, that fight is just beginning. And so I talked to this policy analyst at Cato yesterday, and he said a number of things you actually said about this yesterday, the need for transparency being very key, because then the people can respond or hold their elected representatives accountable or put pressure on their elected representatives to hold the agencies accountable if we know what's going on. And you've criticized, and I agree with you, that the way this has come about, I'm very glad that things like the Twitter files have helped give us much more information, but it was selective. We know we haven't gotten the entire picture. What if there was legislation that if someone at the FBI sends an email to a moderator at Twitter and says, we think you should be aware of some list of accounts for some reason, what if that immediately gets entered into the public record so we know that they're saying? I think maybe that wouldn't stop it, but at least we'd know about it. Might be the best we can do, and would be an improvement over, again, this is a first step because it's clear some of the activity we're very concerned about could still theoretically pass muster under this list.
I have a few issues here. One is that the Twitter files was a valuable glimpse into the kinds of content moderation decisions that are being made. But it was only a glimpse for two reasons. One is that my understanding is that the bulk of content moderation decisions are made algorithmically, not by people making individual choices about tweets or being informed about problematic tweets by the government or anybody else, or by users who self-report tweets. And two, that even focusing on the kind of documentary evidence that we have in the Twitter files, the journalists who work so hard to bring us reporting from that effort only were given access to a very small sliver of documents, even from the Jack days. So I think Matt Taibbi said he had access or had looked through something like 90,000 documents, which from a former corporate lawyer perspective is not an especially large document review. And given that Twitter has existed since 2009, the 2009 through 2022 trove to search through, it's a drop in the bucket, especially since Musk doesn't seem to have disclosed what the search terms were specifically that generated the files that the journalists had access to. And there was no specification in any kind of privilege log to talk about what was withheld from what the journalists were able to look through. So there's a lot of unknowns there about how much more there is to know. And then the other issue is we know nothing about what Twitter's content moderation behavior has been like other than what we can see, right? We can see him censoring the Elon Jet sites. We can see the inconsistencies around some of the high profile people who were censored and let back and then censored again. But we are not given any transparency about what Twitter is doing now. I think a lot of people have faith that Elon Musk is doing the right thing on the basis of him having revealed the Twitter files. But it could also be the case that the Twitter files are providing somewhat of an umbrella for his own behavior now and going forward. What mechanism is there in place to ensure that he actually isn't continuing a lot of the same policies of yesteryear, especially given some of the concerns about his statements of how he's very willing to bend the knee to authoritarian governments like Modi in ways that go beyond what Jack was willing to do in that exact same situation in terms of being more censorious or more solicitous to those kind of authoritarian speech regimes. So I think this is all well and good, But we need to keep our eye on the prize and remember that the work that the Twitter files started was just the tip of the iceberg, and that if we're genuinely invested in having a free platform where people of all ideological stripes are making decisions that undermine the speech of an important public forum, this can't be an explicitly partisan effort, and this can't be an effort where we just happen to trust the billionaire because he said the right things sometimes to keep our interests at heart. There have to be neutral mechanisms that make all of these people transparent and accountable.
I agree with that. I'm furious with the lack of neutrality from so many in the mainstream and establishment media, weighing in on this judge's decision, which we're finding some fault with some of the reasoning. We're saying, well, here's why it's not going to cover this, and it's a difficult issue. But from all the cable news segments, CNN and MSNBC on this, we're all just, oh yeah, experts say they're going to have a lot harder time stopping you from seeing misinformation now. It's just so breathless and hysterical and just so credulous of this category of national security expert person. That person can do no wrong, and they tell us that this is bad, so we agree. I think it's so unhelpful for having a nuanced, fruitful conversation about how to genuinely improve these platforms.
Can I ask you about this, Robby? I've seen some people, including Schellenberger, tweet about whether or not Congress should revoke Section 230 for companies that aren't sufficiently transparent. And in the past, we've talked on this show about how pernicious the threat of the government has been to revoke Section 230 for sites that it felt like weren't attacking misinformation, right? Or basically using Section 230 as a cudgel in that way. Even if we disagree with the government's, with let's say how Meta might be running its version of Twitter, what do you make of using the Section 230 threat as a cudgel in this context?
I oppose it. That's exactly what I mean. That's part of the argument against the social media censorship regime has been, Joe Biden and his deputies threatened to take Section 230 away from the sites unless they did more to suppress COVID contrarianism.
Yeah.
That was wrong and bad. And also, the immediate, whatever you think about, if you're mad at the companies, you don't like that they have this protection, the immediate effect of changing Section 230 or taking it away would be a vast silencing, would be that the platforms would have to censor more speech because they can't take on increased liability.
Yeah.
It's not pointing out the double standard that they have this protection that other media companies don't have is fine. But again, I'm a free speech absolutist. I'm not obsessed with the concept of defamation being protected anyway. And I would sooner extend this protection to other entities than take it away from the ones that have it, because taking it away would just, again, effectively, it would silence millions of us.
Well, Schellenberger is a friend of the show, and I look forward to having an opportunity to talk to him about what he means here. But it is concerning to me that this looks like, based on politics, deciding that a tool, which I think we agree was a bad one to use to try to get your way on these apps, suddenly being seen as the right thing to do, revoking Section 230 when it's attacking an app like, say, Meta's app, which one might not like for political reasons.
And he said he wants to do that or impose transparency.
Yeah.
I would just say, so let's not take away Section 230, and I would support Congress should impose the transparency on the government side of it, because that would be less subject to, if you impose transparency on the company, company could sue you for
That's going to miss some stuff too, right? Because companies make independent decisions. Part of what was so not funny, but ironic about the Trump censorship, pulling Trump off of Twitter decision it was the Hunter Biden decision, was that the Twitter files revealed that it wasn't that the government had to say, take the Hunter Biden files down. It was that they had done so much work leading up to it, talking about the risk of election interference and Russian interference, that it was already incepted into the brains of the Meta people.
But that stuff is what I want to see. I want to see those kinds of communications.
Sure, but also there's the kind of the argument that Twitter was this liberal bastion and that everyone who worked there was inclined toward content moderation decisions that were just more liberal in nature is also not going to be captured any natural
Sure,
bias is not going to be
captured. And that was my notion, but that notion was gradually undermined by seeing so many email exchanges between moderators and the FBI where they say, oh my God, more of this nonsense.
Yeah.
So I would like to see more of that going forward. And we will have more Rising right after this.